Hi, I'm Jeff Sikkenga, Executive Director of the Ashbrook Center, and this is The American Idea, where we discuss the ideas, people, and events that have made America what it is today. We believe that by understanding our history and our principles, we can better live up to the promise of the American founding and preserve our ongoing experiment in self-government. Welcome to The American Idea. Want to welcome you to this episode of The American Idea. Today we're going to be talking about an important, if understudied, legal doctrine and legal conversations that's happening now around the country with renewed interest and renewed importance. And we're talking about the Chevron Doctrine, as it's been called, and its importance for thinking about the United States Supreme Court, the administrative state, and the rule of law in the United States. Today, we're joined for that conversation by Mark Chenoweth. Mark is President and Chief Legal Officer for the new Civil Liberties Alliance, which is a very active organization engaged in litigation. And Mark will be able to tell us a little bit more about the organization and their litigation as we go through the conversation today. He is a graduate of Yale and of the University of Chicago Law School, and was also a law clerk on the Sixth Circuit Court, which used to be, I think, led by our old friend Alice Batchelder, who has been well-connected and a great friend to the Ashbrook Center. So, Mark, if we're not direct friends, we're at least indirect friends, and thank you for taking the time to join us today.
I'm glad to be with you. It was a privilege to sit. I clerked for Judge Boggs on the Sixth Circuit. We sat with Judge Batchelder at least once that I recall, and it was a pleasure to do so. And spent many weeks in Cincinnati during the course of my year clerking on the Sixth Circuit. So I have fond memories of that.
Tell us, I think a lot of our listeners, as you know, are deeply concerned with U.S. history, the United States Constitution. They know something, of course, about the Supreme Court and even some legal doctrine. We're hearing a little bit more about this thing, so-called Chevron, out in the media today. But take us back. What are people talking about when they talk about the Chevron Doctrine, and why is it important for us to understand?
Sure. So the Chevron Doctrine goes back to a U.S. Supreme Court case, Chevron v. Natural Resources Defense Council, which was decided by the court in 1984. It was decided by 6 justices. There were 2 justices sick that day. If I remember correctly, it was then Justice Rehnquist and Justice Marshall were sick. And then there was one other justice who was recused from the case. And I can't remember offhand who that was. It might have been Sandra Day O'Connor. And so there were only 6 justices, which is the bare minimum allowed to hear a case. And so you might think that they would have shied away from doing something as significant as this case became. But that's part of the story here. They didn't think that they were doing anything all that significant. They didn't really mean to create, or at least that's the story that's told, this new doctrine of administrative deference, at least not to quite the same extent that they wound up doing. And so the Chevron Doctrine dates back to that case, but it evolved subsequent to the holding. That particular case had to do with the Clean Air Act and what's a stationary source, and the EPA, which was then led by Justice Gorsuch's mother, Ann Gorsuch, under the Reagan administration, was trying to argue for a little more flexibility within plants so that a certain rule didn't apply smokestack by smokestack, but applied to the overall sort of general vicinity of the plant. And they thought that that would allow there to be some more sort of cost-effective air pollution strategies put into effect. So that was the controversy that was at issue in the case. But the particular holding that came out of it, aside from sort of the Clean Air Act holding, but this doctrine that came out is this idea where courts are told in these administrative cases, these cases about federal regulations, to first use all of the sort of statutory tools that you would use in any other case to try to figure out the meaning of the statute and how it would apply to the situation. But if you get to the end of applying all those statutory tools and there's an ambiguity or a silence in the statute, then at that point you should defer to the agency's interpretation of the statute. And then so step one of Chevron is apply all the tools, see if there's an ambiguity or whether you can resolve that ambiguity as a court. Step two, if you decide there is an ambiguity, then defer to the agency's reasonable interpretation of the statute. Again, if it's reasonable and if it's a statute that's under the purview of that agency, which of course the Clean Air Act was under EPA's purview. So that's what the Chevron doctrine is. Maybe we can get into why that's so problematic.
So in layman's terms, it's something like, as you say, if a federal judge doesn't not quite sure what the law means that's involved in the case, and there's a federal agency, they should defer to that federal agency's interpretation of the law.
That is what Chevron holds, yes.
Okay. Why is that important?
So it affects every single administrative law case out there, and as one measure of the importance of this case, it's apparently either, depending on who you talk to, the number one or number two most cited Supreme Court case ever in the lower courts.
Wow, ever.
So it's either Marbury versus Madison or Chevron. Those are the two cases that are the most widely cited. And so that's just the scope of it. This isn't limited to EPA cases or Clean Air Act cases. This affects every single case that involves a federal agency, or even a case that involves a federal regulation. It wouldn't necessarily have to have a federal agency on one side of the case. But whether you're suing the federal agency or the federal agency is suing you, the vast majority of the time, the Chevron doctrine will come into play. And it's the sort of standard go-to rubric that a court will apply in deciding these administrative cases. And the problem for the average litigant is it really puts a thumb on the scale for the government to prevail in these cases. And so there's academics have looked at this, and there's statistics that that about 70% of the time courts get to step two of the Chevron analysis. And then once they get to step two, the government wins about 90% of the time. And so just this doctrine alone, really, you can just see how that tilts the whole playing field in favor of a federal agency in all of this litigation. And that's one of the things that we pointed out to the court and that we object to.
And tell us a little bit more about how the Chevron defense has actually been used. What kind of federal regulations and bureaucratic actions have been upheld because of the Chevron defense?
Well, gosh, everything under the moon that you can imagine. But the particular case that we had in front of the Supreme Court was involved the national, and this will just give you a sense of, an agency as large as the EPA, and then our case involved a much smaller agency, the National Oceanic and Atmospheric Administration, NOAA, and the National Marine Fisheries Service underneath NOAA. And they had a regulation that they implemented that tried to, well, first of all, there's something that Congress passed called the Magnuson-Stevens Act back in the 1970s. That statute governs different rules of fishing in the waters off of the coast of the United States, including in the North Atlantic, where our clients fish for herring. And in this herring fishery, one of the things that the Magnuson-Stevens Act and some of the subsequent amendments required was for there to be observers on these boats occasionally that would look at how the fish stocks are doing. They would maybe look at what bycatch the fishermen are bringing in. That means the fish, you're fishing for herring, but you accidentally bring in something that's not herring. How often is that happening, or what kinds of species are being are being netted, sort of accidentally or incidentally in the process. And they look at some of these other kinds of things, and the fishermen were fine with that. They don't love having these monitors on board because it's they have to provide a berth for them, because these are overnight trips. Our clients are out for sometimes a week, 10 days, maybe even more than that. They have to provide meals for these monitors who are on the boat, and then these monitors, I mean, they can get in the way, or they're also just not necessarily the most. They don't have the best sea legs. These aren't seasoned people, and if you're out in the North Atlantic with 15-foot swales, I mean, a lot of these monitors aren't, they're not seasoned, and they may just be filling their boots the whole time, and that's an extra problem for the for the fishermen to have to deal with, and for the captain to have to deal with. Not only trying to keep the boat, not only trying to fish and keep the boat, through rough seas or something, but now you have somebody on board who's sick through the whole thing too. So
Right.
it's a
So
problem. But
what's the controversy with the monitors then under the law?
so the controversy is that Congress stopped funding the monitors at the level that NOAA thought that they ought to be funded. And so NOAA said, well, we want to keep putting more monitors on the boat. So they passed a regulation passing the costs of the monitors on to the fishermen directly. And that's a problem for a few reasons, including the fact that Congress never gave the agency the power to do that. In fact, the statute did give the agency the power to do that in a couple of particular instances. So for foreign fishing vessels fishing in U.S. waters, NOAA is allowed to put monitors on those boats and charge those boats directly for those monitors. Well, that makes some sense that you might charge foreign vessels for that. They also allowed it in the Northern Pacific, which is a very different fishery where there are higher margin fish. So you can think of Alaskan king crab or something like that. These, not herring, which is a much more low margin fish, but and even there they capped the cost at 2 to 3% of the catch for what the agency could charge for these monitors. Well, what they're charging trying to charge under the regulation in North Atlantic is 20% of the cost of the herring catch. So Congress just never approved that, and so you have an agency that's acting outside the scope of its statutory remit, and that's a huge part of the problem here. And you might say, oh, well, didn't the lower courts decide it that way and rein the agency in? Well, that's where the Chevron Doctrine comes in, because in this case, our case was in the District of Rhode Island, and then in the First Circuit Court of Appeals in Boston. And in both those places, the court looked at it and said, well, if you look at this under Chevron, maybe it's a close question, but we're going to defer to the agency and decide that they can do this. And in the companion case called Loper Bright that came up through the DC District Court and the DC Court of Appeals, they had the DC Court of Appeals decided the same thing, that applying Chevron, the agency wins. But there was a dissent, at least in the DC Circuit.
So what effect does a rule like that have on your clients, on the fishermen?
Well, it just makes it really unprofitable for them to go out and try to fish. It's something like $700 a day cost for these monitors, and that's more than the crew get paid on these ships. The rule was written to have some sorts of exceptions or exemptions. So if you captured below a certain tonnage, or if you only went out for the day and came back that same day, then you can have an inspection on the dock side rather than having a monitor on the boat. There's some things like that, but none of those things applied to our clients, because they have a freezer trawler, which means that they're freezing the fish as they are catching them, which is efficient in one way, but you can't then inspect them on the dock side. So they just weren't able to take advantage of those exemptions. So it's just very expensive for them to have these monitors. And our clients don't always fish for herring. So they might go out and they might find butterfish, or they might find squid, or they might find mackerel. And so they're paying for this herring fishery observer to be on the boat, and they might not even catch any herring on the entire trip. And yet they're still having to pay this person $700 a day to be on the boat. So it's just not, it's not
So in a
statutorily allowed.
situation like this, I'm just wondering now, and I'm sure many of our listeners are thinking, in a situation like this, your clients, do they, can they approach the regulatory agency and tell NOAA, hey, look, this regulation is extremely burdensome. It's not necessary. It doesn't make a lot of sense. Will you please not apply it to us? Will you please repeal it or make an exception?
Right. And so this regulation was issued at the end of that entire process. So our Megan Lapp is the name of the woman who works for our client Fisheries, who attended all of these regulatory hearings. And you can listen to her talk about it. There's a video on our website where she talks about it a little bit. She's given some interviews this month as well, talking about how she went to every single one of these meetings that was held, every one of these opportunities to weigh in on how to construct the regulation or what problems there were with the regulation. And she explained all of this to all the regulators every chance she got. And they basically just ignored her and went ahead with the regulation that they wanted to do anyway. And that's another problem, Jeff, with Chevron, is because the agencies know that they're going to get deference in court. And because they know that, they don't have very much incentive to do something that is closer in line with what the statute allows. As you know, the attorney who argued this case for us in the Supreme Court, a guy named Roman Martinez, who's a partner at Latham and Watkins here in DC, did a fantastic job. Roman used to be in the Solicitor General's office at the Department of Justice, and he told us that his experience when he was in the government dealing with these agencies is they don't look at the statute and say, what does the statute allow us to do, or how can we best comply with the statute? Instead, they look at the statute and they say, how far can we push this and still get Chevron deference to how we want to do things? So it just really, you know, it creates these, you could call them degrees of freedom for the agency, but that's degrees of unfreedom for you and me, or degrees of cutting back on liberty for you and me that Congress never approved.
Before we continue with our conversation, I'd like to take a moment and ask you to learn a little more about the Ashbrook Center and how you can help us continue our work with teachers, students, and citizens.
I'm Chad Kiefer, Director of Philanthropy and Strategic Partnerships here at Ashbrook. At its heart, America's story is about the lives of patriots who have given their last full measure of devotion to preserve and protect what it means to be an American. But the tragic truth is that the American story is being rewritten as one of oppression and despair. Back in 1776, the founders took a chance when they created a new government built on principles of liberty. They took a chance on America. Now I'm challenging you to do the same. Your gift to Ashbrook today reaches students, teachers, and citizens across the country, helping them to understand why America is worthy of their devotion. With so many forces eroding our history and taking away from our principles, isn't it time we give America a chance? Your investment is encouraged now more than ever. Please visit us today at ashbrook.org/support.
So you've talked a lot about, and this is really important for us to understand, the kind of economic impact on people like your clients who are just trying to make a living fishing. What about the constitutional impact? What impact does the Chevron Doctrine have on the fact that we ought to be ruled by the Constitution and by laws made by Congress under the Constitution?
So fantastic question, Jeff. And maybe we should have even started there, because that's certainly why the new Civil Liberties Alliance took a particular interest in this case. We were founded by Professor Philip Hamburger, who is a constitutional law professor at Columbia Law School in New York. And he wrote an article about Chevron bias back in 2016. It's in the George Washington Law Review, if anybody wants to go look that up online. And the particular arguments that Philip makes against Chevron deference are ones that had not really been made very much before his article came down. And he makes two main constitutional arguments. First, under Article 3, the judicial power is given to Article 3 judges. It's not given to the executive agencies. It's not even given to Congress. And so if the courts are deferring to the administrative agencies as to the meaning of the law, then they're not really fulfilling their duty as judges. The Constitution goes to a lot of trouble to protect the independence of the judiciary. I mean, everyone thinks of life tenure and not being able to reduce the salary of judges, but there are a lot of other things in there too. I mean, no religious tests. You can't serve in Congress and be a federal judge at the same time. You can't serve in the Electoral College and be a judge at the same time. There's all these things that are done to ensure the independence of judges. And when they turn around then and instead look for the meaning of the law from someone in the executive branch, well, they're looking for someone who isn't protected and doesn't have independence. And in fact, in a sense, you're allowing the agency to be a judge in its own case, which is an ancient principle of justice, that you never let someone be a judge in their own case. And yet that's what happens when you defer to the agency's interpretation of the law here. So that's a real problem from a structural constitutional standpoint, that you're giving away the Article 3 responsibility of the judiciary. And, you know, coming with that too, if you think of it as the Supreme Court had come up with this decision, they're imposing this obligation on lower courts to follow that precedent, and in a sense to to ignore their constitution, the oath that they took to uphold the Constitution. So every time they follow Chevron, they're really not following Article 3, and that's not right either, to impose that obligation on lower court judges. So that's part of the problem as well.
Yeah, it makes me think of Federalist 78, where Alexander Hamilton says it's the peculiar province of the courts to say what the law is. Mm-hmm. And he seems to contrast that with the legislature and with the executive branch.
And we talked about Marbury versus Madison before. One of the holdings of Marbury versus Madison is that it's the obligation of the courts to say what the law is. And so that's definitely a long-standing original understanding of the meaning of Article 3.
So one of the constitutional challenges, as you're saying, then, is that it has really undermined the power of the federal judiciary to its ability to exercise its judicial powers as originally understood in the Constitution. Are there other corrosive, harmful effects of the Chevron doctrine?
There are. I mean, as you say, it clips the wings of the judiciary, and it really prevents them from being able to rein in an administrative agency that has exceeded its statutory remit. So part of the job of the courts is to make sure that the executive branch is doing what Congress told it to do, right? But if it's deferring to the executive branch, then it's not really making sure that it's doing what Congress told it to do. And there's this they refer to it as a fiction, that there's this fiction that under Chevron that there was a delegation of authority from Congress to the agency, particularly when there's an ambiguity, that there was this delegation where there's an ambiguity or silence. There's a delegation to the agency to construe the meaning of the statute. But that's not really true. First of all, it's hard to see that a silence delegates anything. And if there's an ambiguity, it's really hard to see that that's a delegation either. So, under Article 1 of the Constitution, all the legislative power is given to Congress, right? That's Article 1, Section 1, the very start of the Constitution.
Right.
All legislative power is given to Congress. So if you start saying, well, wait a minute, we're not even talking about express delegations, which, there's a whole non-delegation doctrine we can get into some other time about how much power Congress can give away. And the answer is not very much, but certainly if you're talking about delegations that aren't even express delegations, they are implied or even silence, and you start reading that as empowering executive agencies, well, then you've got another structural constitutional problem where you've taken Article 1 power and you've moved it over to Article 2 instead. And if Article 3 judges are deferring to that, that instead of upholding that line between Article 1 and Article 2, they're actually abetting the leakage of Article 1 power into Article 2 agencies. And that's a real problem with Chevron deference as well.
So it sounds to me like you could end up with a situation where you have really a breakdown of checks and balances, particularly on bureaucracies in the executive branch.
You said it much more succinctly than I did, Jeff. That's exactly right.
And of course, constitutionally, that's a tremendous problem when you think about a Republican form of government, where the people are supposed to be represented or governed by laws created by their own representatives, and have to be. And shouldn't those laws be clear in what they tell people they can do and not do?
The laws should be clear, and they should be written by Congress, which are the people who are elected to write the laws, and which the Constitution empowers to write the laws. And if instead they're allowed to say vague things, or their silences, for crying out loud, are construed as somehow empowering agencies to do things, then you're really losing self-government. There's not really the ability. I mean, we were talking about Megan going to all of these administrative hearings and so forth. Well, sure, they listened to her, but they didn't really listen to her, right? They didn't actually have to do anything. And
they didn't feel the same kind of need to listen to her that an elected representative might feel because they're elected.
That's right. If this were a congressman from Rhode Island, I guarantee that they would have listened much closer to Megan's concerns than this federal official from from the Fisheries Management Agency.
Well, you obviously, the cases now have gone up. Are you hopeful? Is there any reason to believe that the federal courts, including the Supreme Court, are ready to take a second look at the Chevron defense?
So we do think that the Supreme Court's ready to take a second look. For one reason that we think that is there was more than one question presented to the court in this case, but the only one they granted was the should we overturn the Chevron Doctrine question. And so that tells you that they're not really looking to nibble here. If I guess if I keep with my fish metaphors, but that I think they are looking to deal with the big whale. And there's other sort of issues in play here. One of them is the Administrative Procedure Act, which was passed in 1946, and it was essentially Congress reacting to a lot of what had happened the previous decade and a half in the construction of the New Deal, and all the creation of these new federal agencies and a lot of federal power under the Roosevelt administration that hadn't really seen before. And Congress said, now, wait a minute, we want the courts to have a role here. And the Administrative Procedure Act tells the judiciary, as a matter of statute, and we already know this from the Constitution as we were talking about it, but it also says, as a matter of statute, we want the judiciary to have to give statutes and constitutional provisions the same level of review. Well, we already know that the courts don't defer to federal agencies on constitutional questions. No one disagrees about that. So if they're also not supposed to defer to them on statutory questions, then Congress has already said in this law that they don't want something like the Chevron Doctrine. And so we have, we live in a age now where the judiciary for the last couple of decades has become much more textualist. They care a lot more about what the statutes say, and more than they did back in 1984 when Chevron was passed. And the Chevron case itself never talked about the Administrative Procedure Act, never came up in the discussion of the case. And there's some reasons for that, including the fact that the Clean Air Act has its own provision that's a little bit different from the APA. But at no point has the court ever really dealt with the fact that Chevron does appear to be against the text of the Administrative Procedure Act. So that's another issue that the court spent a lot of time on in oral argument this month, saying, how did this happen and why was this never grappled with over the last 40 years? And does the Administrative Procedure Act really mean that we can't continue to follow Chevron deference? And so that's, that was an important part of the conversation as well.
So when you look at the state of the current court, Are there justices who have given indications, obviously besides the court taking the case itself, is there any sense that you have that there's a appetite to overturn the entire defense or to reform it in some way? What's your sense now that the case is in front of the court?
Yeah, well, now that we've had oral argument in front of the 9 justices, we definitely heard voices from three of the 9 justices. I would say Justice Sotomayor, Justice Kagan, and Justice Jackson were more friendly to Chevron deference, looking for ways of sort of either keeping it, or they were arguing on stare decisis grounds that we shouldn't change this precedent. And at most they were saying, well, should we maybe mend it, don't end it, kind of a conversation. But the other 6 justices weren't singing from that same songbook. And in fact, Justice Kavanaugh, Justice Thomas, Justice Alito, and Justice Gorsuch were all in more or less signaling the problems with Chevron deference of one kind or another. And Justice Alito wanted to know, well, why did people think this was a good idea in the first place? And he asked both sides, that question, and asked, actually in both cases, he asked the Roman Martinez in our case, and Paul Clement argued on behalf of Loper Bright. He asked Paul as well that question. And so they were explaining kind of what I did, that the court has become much more textualist now. Back then, when Chevron was decided, there was a feeling that a lot of the lower court judges were engaged in judicial activism, that maybe by deferring to the agencies, you could rein in some of that judicial activism. And so that was the idea. But now what we've seen is that Chevron has instead turned the agencies loose, and we have agency activism of a sort that's even harder to rein in than judicial activism. And so it might have seemed like a good idea at the time to relax some of the constitutional constraints on the way that we divide government. And it turned out that was a failed experiment. It was a really bad idea. We need to go back to doing things the way the founders set it up.
For your organization, the New Civil Liberties Alliance, obviously this is a very important case that you've been involved in. You have other cases as well, as I understand, that you are actively litigating. Tell us a little bit more, because obviously this has the potential to be a landmark decision, as you say. But you besides this, other cases that your organization takes and the kind of cases that you look out for.
Sure. So we probably have 50 open cases, so we don't have time to talk about all of those right now. But one case that Ashbrook folks might be particularly interested in, we are suing the Department of Education over its effort to forgive student loan debt, which again, we don't think that Congress has ever passed the kind of statute it would need to pass to empower the Department of Education or other federal agencies to forgive student loan debt. And the Supreme Court agreed with us about that last June and struck down the administration's effort to forgive close to $500 billion in student loan debt without involving Congress. Unfortunately, the administration's reaction to that was to come up with a whole bunch more programs trying to forgive slightly lower amounts of debt in similarly unconstitutional ways. And so we have, we're continuing to push back against that and try to get the courts to rein in that illegality. Something else we're very involved in, and that we're going to be in front of the Supreme Court on in March, is the social media censorship that we've seen take place, particularly under the current administration, although some of what we discussed began earlier than that during the COVID pandemic under the last administration. But we see all these federal agencies that are reaching out to the social media companies and asking them to censor different people's voices, maybe because they're saying something that they don't like about COVID, maybe because they're saying something they don't like about President Biden or about the Hunter Biden laptop or about other topics. And there seems to be this idea in the federal government right now that they have the responsibility to police truth on the internet, and that's not ever something that we've entrusted the government to do. The government can police the line between legal speech and illegal speech, and that's fine. The government can, for example, tell the internet providers to pull down child pornography or something like that. That's illegal. But we've never entrusted the government to police the line between what's true and what's false. And what defenders of this have said is, well, it's not the government that's pulling it down. It's just alerting these private companies to the speech and asking them to pull it down. Well, first of all, the government cannot do indirectly what it's forbidden from doing directly. That's a long-standing principle, and that's exactly what it's trying to do in this censorship situation. The other thing is, it's exerted a lot of pressure on these companies to go along with the government's bidding in this area. So even if we don't think that it takes a coercion standard or a pressure standard to suppress free speech, the First Amendment talks about abridging free speech, which means reducing or diminishing. And it's unquestionable that the government's conduct here has reduced or diminished speech. It has flagged content to be taken down, which has then been taken down. That definitely abridges speech. But even if you accepted a higher standard, I think you would agree that the government's conduct here has pressured the companies to do what they've done and silenced many voices. And by the way, a lot of our clients' speech has been truthful speech. They've said things about COVID, for example. They were saying that there is such a thing as natural immunity. If you've recovered from COVID, you have those antibodies. You might not need the vaccine, or certainly not right away. Or this may have originated from the Wuhan lab, which was something the government was suppressing speech on that for a while. Or one of our clients, even Jeff, volunteered in the vaccine trials. So this is not someone who's anti-vax. She volunteered to be in the trials and then was injured as a result of getting the vaccine. And this wasn't her diagnosis. This was the NIH, the National Institutes of Health, diagnosed her as being vaccine injured as a result of getting the vaccine during the trials. And so she had set up a support group on the internet to try to help out other people, not to be anti-vax, not to spread negative information, certainly not to spread false information, but to share the truthful information about her experience and to reach out and be a support group like a cancer network or something like that, to be a support group to other people experiencing what she had experienced and going through the suffering that she was going through. And the government shut that down. It asked Facebook and these other groups to take down those support groups and that sort of speech. So really very pernicious kinds of social media censorship taking place, all in violation of the First Amendment. And we are really fighting hard to stop the government from doing that.
Well, we will be fascinated to hear the outcome of that case, and of course also the case you have with the Supreme Court on the Chevron defense. Mark Chenoweth, thank you so much for taking the time today to join us on The American Idea.
Good to be with you. Thank you, Jeff.
Thank you for listening to this episode of The American Idea. If you enjoyed this episode, remember to subscribe at Apple Podcast, Spotify, or wherever you get your podcasts, and leave a 5-star review. If you want to learn more or get involved in Ashbrook's vital work, visit our website, ashbrook.org.